Welcome to Slaughtered Sheep. I'm your host, Matt Daly of MRD Consulting, and you are listening to the Law Dog series in the Slaughtered Sheep podcast. The Law Dog series showcases legal issues, legal planning, legal and regulatory pitfalls, traps, and of course, legal wolves circling small business owners, posing an ever-present threat to the coffers and bank accounts of small businesses. Today, we have invited onto the show a very experienced and high-level lawyer in the form of Dan Kadlec of Larkin Hoffman law firm based out of Minneapolis, Minnesota. Dan is a corporate attorney with Larkin Hoffman and is also Larkin's CFO. Dan advises his clients in a variety of corporate matters, including mergers and acquisition, financing, and succession planning. The law firm of Larkin Hoffman has been representing my various development and consulting companies for over 30 years. Larkin Hoffman has also represented the various ventures of my father, Bob Daly, and my brother, Luke Daly, for the last 3 decades. I've retained half a dozen Larkin Hoffman attorneys in the areas of construction law, employment law, contract law, mergers and acquisitions, and other corporate interests. I can attest to their high level of service and overall knowledge of business law and complex business transactions. I would recommend their firm to any small to medium-sized business and would be confident that they would be well taken care of. We've brought Dan on the Slaughtered Sheep podcast to discuss various wolves circling small businesses pertaining to business entity structures, mergers and acquisitions, and related topics. Today, we will discuss single and multi-member LLCs, LLC formation, and operating agreements, corporate veil, and documents and issues pertaining to mergers and acquisitions. With that being said, I'd like to introduce to our listening audience of faithful small business sheep, Mr. Dan Kadlec. Dan, welcome to Slaughtered Sheep.
Thank you, Matt.
It's good to have you here, Chief. Are you ready to fend off some wolves and save some sheep today?
Absolutely.
There we go. That's the attitude we need. So before we jump into the various corporate law topics and issues, I'd like the audience to get to know Dan the person, the student, and the ever-evolving law practitioner superstar at Larkin Hoffman. Let's start with your childhood and where you grew up. What were the formative years like for Dan?
Matt, I'm a transplanted Iowegian. I grew up in Iowa, born in Cedar Rapids, and then went to high school in Des Moines. And my undergrad was at the University of Northern Iowa in accounting. And I liked swimming, golf, all things water. In fact, one of the reasons I ended up here in Minnesota is our family vacationed up here in August for 2 weeks every summer. And I just fell in love with the state.
Welcome to Minnesota. So how long have you lived in Minnesota yet?
I moved up here in 1988.
Got it. Okay. So what is that? That's 30 some odd years, close?
Yeah, I've been up here 36 years.
36 years. Got it. Okay, perfect. Okay. So you moved to Minnesota, and so tell us what happened next.
So the reason I picked, besides wanting to live in Minneapolis, I got my degree in accounting at the University of Northern Iowa. And my goal was to move to Minnesota, get a boat, a camper, and never spend another weekend in the Twin Cities. And next best thing, actually something better than that happened. My folks bought a lake home up north. I didn't have to do all that. I just had to go up there and help them with that.
And so whereabouts was that up north?
That's in Hackensack.
Got it.
Just north of Brainerd.
Sure. Beautiful area.
Yep. Love it up there. And I've been married since 92. And I have 2 boys that both live in the area. And they're both married. So I guess from that standpoint, I can say mission accomplished there.
Nice. So they didn't run off to California and you head down
No, I think
Minnesota.
I think I can thank my parents a little bit because they loved going up to the cabin too.
And so you still have the cabin?
It's still in the family, yes.
Nice. Are you a big fisherman?
I'm a big bait grounder. I love to fish.
You attempt.
Yes, I love to fish, but the fish are pretty protected from me.
Is there decent walleye fishing in around there?
If we want walleye, we usually go to a different lake, a Leech Lake or something like that. Our lake is pretty good for crappies.
Got it. Those are fun.
Yeah,
we
love
you hit a pool and they're nice. Good. So obviously, so you took that accounting degree and then you went to law school.
Right. I worked for 3 years with then Ernst & Winnie, which became Ernst & Young, one of the big 4 accounting firms. And after 3 years, went to law school here at the University of Minnesota.
Interesting. So was that your plan initially in your undergrad, or did you fall into the law career?
I had an idea that I would pursue an advanced degree. I wasn't exactly sure what, but after a couple busy seasons in the Big Eight accounting firm, I knew that wasn't the route I wanted to pursue the rest of my life, and decided law was maybe a better avenue.
So you were out of school for a few years, but obviously you made the transition. Was it a little rough going back to school after being in the working world, or not too bad?
A little bit, but the adjustment only took me about a semester.
Got it. So you went to law school, you graduated. Did you jump right into Larkin Hoffman, or were there other firms before that?
No, Larkin Hoffman's been my home for my entire legal career. I started there as a summer clerk after my second year and stayed on. They were gracious enough to hire me in their corporate department, which is exactly what I wanted to do. I did not want to do litigation. I try to keep my clients out of litigation if possible, but sometimes it's a necessary avenue to reach whatever objective they're trying to accomplish.
Interesting. And so when that situation unfolds in that manner, are you the litigator, or do you bring in a Larkin Hoffman?
No, we have about 80 attorneys at our firm, and I am solely in our corporate transaction group, and my practice focuses on M&A, finance, and being basically outside general counsel to small businesses that probably don't have their own in-house counsel. And that runs the gamut. And if I need expertise, that's one reason why I'm in a firm. I can rely on my partners for all the various different matters that might come up, whether it's employment, intellectual property, real estate, land use, tax, all that type of stuff.
So obviously with Larkin, you have a number of resources with your fellow practitioners to go to in those areas that you just listed off. But a day in a life for Dan would be, and I'm just going to take a stab and you can tell me where I'm off, but I'm assuming that LLC or entity formation would be something that you would be involved in if one of your clients wanted to start a new business. Is that correct?
Absolutely. If a client comes to me and they have a business idea and they want to pursue that, we talk about choice of entity, what would be the best option for them. I often work closely with their accountants if they already have an accounting relationship, because that decision is very dependent on the tax situation. We talk about if they have partners or co-owners, how to structure that relationship. I'm sure we'll get into that here on the podcast. And everything else from the IP things that are related to starting up a business. They may have a trademark or an idea or a product that they want to patent. Probably these days, more often than not, it's a service-oriented business. And then they have to look at the contractual relationships as well.
Got it. So for instance, just to run the gamut, so it would be entity formation. If it's a partnership, it would be a partnership agreement, or there might be an operating agreement for a multi-member LLC per se. I'm guessing that you probably get into employment contracts for the management team and the officers in terms of the drafting and negotiating the terms and the whole 9 yards.
There can be employment agreements. There can be some sort of equity or bonus arrangement, deferred compensation. It really depends on the type of business and the type of, do they already have a bunch of key employees or key relationships that they want to incentivize further? Maybe giving them, quote unquote, a piece of the action. And what does that look like?
Got it. And that can get complex,
It can get very complex. And
even for small businesses.
my approach to that is to try to keep it as simple as possible. But the main thing is to find out what the objectives are. And then we work on the more simple approaches. And if those aren't going to meet all the objectives or the parameters that the client has or the situation requires, then we work from there.
Got it. And that'll definitely be a topic for a future podcast. I get these inquiries a lot from my small business owners. They want to retain key employees and they want to offer some kind of equity-based compensation or incentive-based compensation that could be converted into equity, et cetera. And it's a complex, delicate phenomena, if you will. I don't think they realize the tax implications that you run into, all the various scenarios that might trigger whether or not they get equity and how much in the whole 9 yards. So that's definitely a podcast. I think that just might be the only topic that we would discuss on that podcast. There's so much to unpack on that.
There is.
However, you were kind enough to come on this show, and I want this to be a journey for our listeners in the area of corporate law and corporate structure. We need to start with the basics and fundamentals. Let's talk about, at least with my client base, the most commonly used entity structure, which is an LLC. I'm going to recount to you my history with LLCs, and then you can put a finer point on it, given the legal and maybe even legislative background on it. But I recall when I was at Arthur Andersen in the late 80s or the early 90s, that LLCs, at least in my universe, were coming onto the scene. And when I left Arthur, went into the casino business, the first entity that I formed was an S Corp. It was a quasi consulting firm, but the LLCs were spreading like wildfire, and it just seemed that there was so much momentum behind them, the flexibility, et cetera. And then my next entity I formed was an LLC. I probably formed 24 of them since then, at least. And I've never looked back. I've never formed, at least for my own single member entities, I've never formed anything other than an LLC. So maybe you could talk about just briefly the intent was with the legislation when states passed these or enabled these, if you will, what the reasoning behind it was from the perspective of a business owner, the advantages. Before we get into this, Dan, it's disclaimer time for Matt Daly and Slaughter Cheap. We need to let the listening audience know that we are not giving out legal or tax advice on this show, but we are raising awareness of legal issues, structures, techniques, and corporate law so that listeners can consult with their own tax advisors and legal counsel pertaining to the issues discussed.
So LLCs, that's an acronym for limited liability company. Mm-hmm. It's company, not corporation. Some people still refer to them as limited liability corporations, but they are very different than a corporation. The first LLC act or statute in the U.S. was actually in Wyoming in 1977.
True.
It goes back that far. But most states, including Minnesota, didn't really jump on the bandwagon until the late 80s, early 90s.
Okay, that makes sense.
And the impetus and the objective behind those statutes and acts were to allow business owners to form entities that had a limited liability shield, like a corporation, but be taxed like a partnership, flow through taxation, and not have an entity level tax.
That's right. Got it. Yes. So this is all coming back. I remember I've used them for so long. It's breathing oxygen. I just take it for granted. Yeah, forming an LLC, I'm not even thinking twice about it. But
and as you said, it really is the entity of choice. I was at a continuing legal education seminar last year, and the Secretary of State for Minnesota comes and speaks annually. And the vast majority of entities formed in Minnesota, it's probably over 2/3, are LLCs.
Got it. And especially, clearly there's other options out there. There's C Corps and S Corps, and there's just a number of other iterations out there. I don't even want to get into public benefit companies and some crazy stuff that's popped up. But it's safe to say that it's pretty tough to go wrong with forming an LLC. If you're a startup, contractor, a small-time real estate developer, or service provider,
it would never be a wrong choice. There may be better choices depending on your particular situation, but the beauty and kind of the curse of an LLC is their flexibility. And we can tailor them to your specific need, whether it's a single owner, whether it's multiple owner. You can elect to have different tax characteristics. They can be a partnership, they can be disregarded, they can be a corporation for tax purposes. So you can almost do anything with an LLC, and that's the double-edged sword with them.
And why would you say that? I'm a little curious. Intimately familiar with the concept of the double-edged sword. I use it all the time when I'm talking to my clients. But what's the other edge of the sword on this where you can hurt yourself?
If you don't do it right, you fall into the default rules. And so if you just think you're going to form an LLC and that's all you have to do, you may not end up with the result, the tax result, the governance arrangement you might want with your partners. unless you plan accordingly. And so that's why you need, particularly in the multi-member LLCs, to make sure that you talk to experienced advisors and make sure that your documents reflect what you actually want.
Absolutely. And I think that in the multi-member LLC realm, which we're going to get to in a minute, I still want to stick with single member for now and some other concepts. But yeah, in the multi-member LLC, and I just see this with my current clients when they want to start taking on partners. My first comment is we need to get a lawyer involved. We can talk about terms all day long and what your intent is, but ultimately we need a good corporate attorney to draft an operating agreement and, and provide other protections for the majority owner. But we'll get into that in a minute. Let's stay in the single member LLC space for a few minutes. Let's go back to the basics and talk about LLC formation.
LLCs, and for that matter, most other legal entities, are creatures of the state. They only exist if you file some document in Minnesota, the Secretary of State. You need to prepare and file articles of organization. Those articles can be pretty short. They just have to have the name, your registered address, and that is basically it. And you can form an LLC. The Secretary of State on their website even has those types of forms available for anybody to file, prepare and file. And for single member LLCs, for the most part, those forms are fine.
Yeah, and I have done that on my own behalf. And I know that many of my clients have, and friends and associates, they get on there. Once in a while, I'll get a phone call and I just give them the same advice of the instructions that you just reiterated. Get a login ID, remember your login creds. And if you can remember where you live and what your name is, it's almost that simple. There's the name search, right? You got to run the name through to make sure you're not doubling up on the name and all that. But in essence, that's really it. And for instance, if you want to open up a bank account in the name of your business,
You absolutely have to have those articles of organization. And the Secretary of State, once those articles are filed and accepted, then they issue a certificate of organization. And your banker, for example, and opening up the bank account will want to see both of those.
Absolutely. And then they typically want the tax ID, et cetera.
Yep.
And that's really the part of the starter kit. That's from a kind of legal or tax standpoint. That typically will get you from A to B. That will get you a live bank account where you deposit that 10 grand or 1,000, or in Will's case, that 500 million that he put in for his firm. That's a whole other podcast. So we're walking through the basics here, and this is great for a lot of the listeners. They don't know. It's somewhat of a self-serving question for Dan and Larkin to a certain degree. Do you recommend, in a perfect world, if you forget about the cost or whatever, but is it a better play and a better strategy to have a Dan Kadlec or some other corporate attorney do this on the client's behalf? What's your call on that?
For single member LLCs or for single owner LLC entities, the biggest question from my perspective is which entity is right for you. And again, we just said earlier that LLCs are fine, but I'm also finding out a number of clients' accountants are recommending that they be taxed as an S corporation, even from day one. You can still have that single member LLC make that election to be taxed. I think if you're going to be just a single owner entity, there's some advantages of being a corporation from the get-go as opposed to forming an LLC and then making the election. But it really is 6 of one, half dozen the other. It's somewhat of personal preference.
You bring up a great point there because I see this a lot. I would say that, I don't know if it's a third or 40% of my clients are single member LLCs filing as an S corp. And I don't do that. I'm a single member LLC. I've never filed as an S corp. Nothing against the S corp fans out there, but I'm just not a big fan. I own one. And my concern with S corps has always been when you take on a partner or another shareholder in that S corp status, they have pro rata distributions, and there's other rules that apply for that S corp. Whereas, as long as you stay in LLC, you can have disproportionate distributions amongst the members, et cetera. And it's just, in my opinion, it feels like there's more flexibility there. But I do see that, and you're absolutely correct. I want to just cover one more kind of administrative question with LLCs, and then I think we can move on to a little bit more of what I'm going to call the meat of the podcast. So when you form an LLC on the Secretary of State website, as an attorney, you're in this universe, but that filing is not in perpetuity. You have to renew it, correct?
Annually.
Yeah, annually.
And that is a common mistake or something that's often overlooked by our clients. They think once I did the initial filing, I don't have to do anything else. And that's absolutely not true. To maintain your entity, you have to file what's called an annual report. It's very simple filing. Again, the form's available online. The Secretary of State these days sends you electronically an email reminder. They used to send you a kind of a 3x5 card in the mail, but they don't do that anymore. And if you don't file annually, you will be administratively terminated, or your LLC will be administratively terminated, which means it doesn't exist. Now, that's not fatal. It's a bad thing. You want to stay in good standing. But if you are administratively terminated because you forgot, you can simply make the next annual filing and pay a nominal fee. I think it's $25 and get reinstated.
I've maintained my LLCs over the years, CPA background and all that. I've been aware of that issue. And I've had clients where it's expired and we'll just nudge them, hey, get on there and renew it. But I guess the question is, from a legal standpoint, that LLC obviously has to be in existence, and it has to be authorized by the Secretary of State in good standing, right? That's the language, right? And so my question is, this is slaughtered sheep. We're talking about wolves. So you let it expire and the wolves move in. You get served with a lawsuit, whatever. What happens to that? Can you just say, hold on a minute there, plaintiff, I got to renew my LLC here. So everybody just sit tight, or what happens in that instance?
That is not a good situation. The impact of not being in good standing or being administratively terminated is basically you lose your right to enforce contracts that you entered into. And you may be able to correct that if before you try to enforce your contract, you get back into good standing. But if you try to do that in the middle of a dispute that's already started, it can be used as a defense or a sword against you, depending on what side you're on. But the other party to that contract can use it as a defense to you enforcing it, or use it to try to seek liability against you personally.
Yeah. And we don't need to spend a lot of time on that. I guess the takeaway is pretty simple.
Stay in good standing. File your annual report.
Stay in good standing. Take a Sharpie and write it in the conference room, but on the drywall. Renew LLC so that you never forget. Is that?
Most people know that they have to file taxes annually.
Yeah.
And you just associate that annual report filing with doing your taxes.
That's a very good tip. I like that. Perfect. Okay. There you have it. You've been warned, sheep. We've got some nuggets here already dropping out from Dan. Let's talk about the administrative faux pas or oversight of not renewing is not good, but let's talk about the concept of corporate veil. And I'm going to just spew out my layman's version of what I believe that it is, right or wrong. But my job is to be the intermediary between the legal giant that is next to me and our slaughtered sheep listeners that have a very basic understanding of corporate law, right? So we talk about corporate veil. I bring this up amongst my client base quite frequently when I'm advising them. And the reason I bring it up is, and this is just very common among small businesses, so we do outsourced accounting. That's our core business. And when we do that, we are knee deep in the transactions every week, every month. And so we see personal expenses and charges going through the business. And our job as the accountant is to run it through distribution so that it doesn't show up on their tax return as a deduction, et cetera. And I believe that we do our job. I've even advised clients that, listen, even when we catch all this stuff and we separate it off of your P&L, it's just not a good idea to be running a fire hose of personal transactions through your corporate and business accounts, period. I also see a whole bunch of related party transactions amongst my client base where it might be with the owner or a partner who's a family member or a family member who's not a partner, where loans are going out the door from the business and they're helping XYZ son or whatever buy a home or an investment property. Now, our job as the accountant is to put it on the books as a related party loan, et cetera. But these are some of the things that I see. We're talking about corporate veil. The concept is that, as Dan described earlier, it's self-explanatory with an LLC, limited liability, right? So the concept is that if something bad happens, and that can be a default on debt, it could be a lawsuit, whatever, that theoretically that liability stays within the entity, correct?
Correct. Another term for it is the limited liability shield.
Got it. Okay.
And that shield is applicable regardless of a corporation or LLC. In fact, as we mentioned earlier, one of the main reasons LLC came about was to have an entity that was like a partnership, which doesn't have a limited liability shield to protect the owners. So the corporate veil is the curtain, if you will, that protects the owner from the liabilities of the entity. And so everything that you were just talking about, Matt, those are things that could allow somebody petitioning a court against the LLC to try to hold the person owning the LLC liable for that debt or obligation.
Exactly. And so I listed off a few instances that I see on a regular basis with my clients. I try to forewarn them, be careful of this. The other issues that I see with my more successful clients is they will form, so they're doing well at their core business and they want to acquire or start up a business that is ancillary. It's not core, but it's related, and they know that they have expertise in it. And in year one, they have 2 entities, and by year 5, they have 4 entities, which is great. I don't discourage that. We talk about limited liability, et cetera, but now we're running into a lot of intercompany transactions, and I tell them, I get it that there's administrative cost to this. I have separate bank accounts, separate credit card accounts, everything, maintain those walls between those entities. And in the vast majority of instances, there's no real monkey business going on per se. It's more convenient. I'm going to pay for these materials for that entity, and we'll just let the accountants clean it up and they can do the intercompany, whatever. I tell them that's our job. We'll do that. But that being said, I highly recommend that you keep those charges within company B. Don't have company A be buying materials for company B on a regular basis, right? Would you agree?
I would agree. The main thing I tell clients in those situations when they're thinking they're compartmentalizing their various different businesses, or maybe they have a business and they have rental property and they want to insulate that from the businesses, or even if it's property related to the business, they want to keep the two separate. They form these entities, they put the assets into those entities, and they think that's all they have to do. If they want the courts and others to respect those entities as separate entities and not responsible for the debts and liabilities of each other, they need to respect the separate identities of those entities. That's the main thing I tell clients.
So here's my answer to that. My answer is a very simple, thank you, Dan. That's my answer. Because I'm going to make all my clients listen to this podcast, right? It's not just for future clients or small businesses out there, right? Because most of them, they get it. They don't fight it. They understand it. I think the world of my clients, and we're here for them. But I tell you, to have a person like you to give that kind of tip, just to say, hey, here's some words of advice for you. Obviously, you're a much stronger authority on this. And yeah, but I will also say this, just in deference to the small business owners, it is a pain. You have to be disciplined. You really do. You need a good office manager. You need a good in-house bookkeeper, because we don't do this for our clients. We're not the ones swiping the cards and writing the checks. We come in after the fact and say, don't make me call Dan up and have him give you a real stern lecture, because that's what I'm going to do. But
It's a lot of other things in life. If you want the benefit, it
Yeah.
doesn't come free.
yes,
You have to go through the administrative formalities, the corporate formalities, make sure you aren't paying one entity's expenses out of the other. And if you are, make sure you set up the appropriate documentation on why you're doing that. And as you said, Matt, sometimes the accountants can fix those things or document them after the fact as part of the annual kind of review tax return process. But the best practice is to get into the practice of treating them as separate entities. And if you're taking money out of one, take it out, put it into your own account, then put it back into the other.
this is just called vindication. That's all this is for me. This is just, I swear, the reason I have such a flat forehead is just banging my head against the wall all the time. But yeah, and I know you see that in your legal practice, right? It's not just accountants, corporate attorneys. All you can do is just advise the best you can.
Yep.
But they don't always listen. But that's why we're doing this podcast. Maybe this is a good way to get through to everybody. It'll put a little more color on it. But
Even though there is an administrative cost to doing all that, the old saying is an ounce of prevention is worth a pound of cure. And hopefully you never get to where you need that pound
yeah,
of cure or have to experience it. But that ounce of prevention, following these rules and guidelines and treating every entity as its own separate individual or entity will save you a lot of hassle, or could save the owner a lot of hassle if things go south for the business.
yeah. And so I want to cover a few more of the, I guess we'll call them avenues, or maybe spears, if you will, that would allow a plaintiff to pierce the corporate veil. And so we talked about commingling of funds, which can be either the personal funds of the owner, but it also could be a related entity. It's not necessarily personal funds, it's corporate funds from another entity per se, right? I believe that fraud, is that also another behavior that might cause that shield to fail?
Absolutely. The two main prongs that the courts look at are, A, was the owner using the entity to perpetrate a fraud? If that's the case, if you followed all the other rules about not commingling or anything, fraud is that F word that trumps everything. I assume most of my clients aren't committing fraud. And in the 30 some years I've been practicing, I'm not aware of any of them that have. So that's a good thing. The other prong where you could have the piercing of the corporate veil is if the courts use the term alter ego. If the entity has been set up and is basically an alter ego of the owner. And there's 8 factors that they look at. The commingling of funds is one. They use that, the term, I think there was the entity a mere facade for the owner, where there was a court case where the owner of a real estate company had 4 personal cars in his entity, real estate entity. And he couldn't possibly argue that they were all business related. So that was used against him. There was another case where the company was insolvent. The plaintiff was seeking recourse against the owner and discovered that the owner had paid $80,000 to make the down payment on his house directly out of his LLC. That was enough to find liability.
You got to be kidding.
Don't pay that out of the LLC. Take that as a distribution, take that as salary, whatever it is, take the money out of the LLC into your bank account and make the down payment and account for that properly. And that would have gone a long ways towards not having the personal liability in that case.
Just that simple act. So in that instance, the owner wasn't even trying to deduct the interest or anything like that. It was just the mere act of taking those corporate funds and using those funds as a down payment on a non-corporate piece of property.
Exactly.
Whew, holy smokes. Okay. One of the questions I have for you is, we talk about the bar. How high is the bar in court? Meaning that in that particular instance, or the commingling of funds or whatever, do courts typically hold a relatively high bar, or is it relatively low? Because that sounds to be relatively low in that instance.
I don't know. As a lawyer, I could probably argue that it's a pretty high bar. The courts do look at 8 factors. And while the case law says none of them is supposed to be determinative, the reality is that the liability of the owner is usually found or fails on either the use of funds for personal use or the commingling, failing to follow corporate formalities in the case of corporations. Now, in Minnesota, the corporate formalities are not necessarily as high. And when I say corporate formalities, that's keeping minutes and documenting internal decisions related to the management or governance of the entity. With the Minnesota's new LLC Act, which isn't so new anymore, it was adopted back in 2015 and went into effect for all LLCs in 2018. The legislature acknowledged that there may not be quite the formalities in an LLC that people are expected to follow for corporations. And so they gave LLC owners, members, some grace on that one prong, failure to follow corporate formalities in terms of documenting internal decisions. Because the reality is, if you're the single member of your LLC, you're making all the decisions. And do you have to document every decision that you made as that owner?
Correct. And so getting back to corporations, jumping over there for a minute. So typically with corporations, C Corp, for instance, you are required to have an annual meeting, a board meeting typically.
You don't necessarily have to have an annual meeting. In Minnesota, you either have regular meetings, which can be annually. And if you haven't had them annually, owners can, or shareholders can call or ask the corporation to call a regular meeting, or you have special meetings. But corporations are required to have a lot more layers. You have the owners that are called shareholders. You have the shareholders who elect the board. You have to have a board of directors, and the board of directors has to elect officers. Now, for most small businesses, or a lot of them, one person fills all 3 roles. They wear all 3 hats. They're the sole shareholder, they're the sole director, or they and their spouse are maybe the sole directors, and they're the sole or only officers.
Just on that note, real quick. So a single shareholder S Corp would still have to follow
Yes.
that. Okay.
Yes.
Okay.
Now, one thing and to keep in mind, from a legal standpoint, corporations are corporations. The difference between a C corporation and an S corporation is strictly an income tax issue. So the same rules from a corporate governance standpoint apply to C and S corp.
For the state. Okay. I got that, but we are focused on LLCs, and we're definitely going to jump back and forth between LLCs and corporations. You just can't. You cannot avoid it.
Particularly when you're comparing and contrasting the benefits.
Yeah. And so the corporate veil, as far as the major avenues, if you will, for a plaintiff, let's just face it, a trial lawyer, a plaintiff advocating on behalf of their client, their job is to recoup damages, remuneration, whatever, from whatever legal source that they can get their hands on, correct?
Right.
And so I'm guessing that in most instances, at least they're going to take a run at trying to pierce the corporate veil or pierce the limited liability shield. We talked about fraud. You said that's the trump card. Doesn't matter what else you do if they could prove, I'm sure it's substantial fraud, whatever that threshold is. But commingling of funds. Any other major avenues that the listeners need to be aware of or be on guard for other than those?
One of the factors or elements is insufficient capitalization. So when you form your company, make sure you put in a reasonable amount, and that may be $100 or $1,000. Capitalize your company, and that's an ongoing thing. When you take out money out of your entity, you can't take out money and render it insolvent. If you do, that's an avenue for at least clawing back the amount of money that you took out.
Sure. The deficit.
Mm-hmm.
Yeah. Interesting. Okay. So I think we spent more than due time on that, but I will say this, the stakes are high. on that for the small business owners. And I also believe that for the most part, they are not as sensitive or aware as they should be of how to maintain that like limited liability shield, but also the consequences of not doing that. I guess as we dig into this, I don't want to beat a dead sheep with a stick too much, but it just, in my mind, from a legal standpoint, once that LLC is formed, as their advisor at my firm, we provide accounting, but we give them advice. They look to me. And it's just something I'm bringing up. I feel like on a weekly basis, monthly, let's think about that corporate. I call it corporate veil. It's the limited liability shield. These are my clients. I care about them. I don't want to see them get nailed. They've given me some ammunition for further discussions with them, and we'll see if it makes any difference. I want to move on. Dan, you're doing a great job of illuminating these topics. I thought I knew LLCs inside and out. I guess I didn't. I've learned a few things about LLCs, and definitely even more. I'm even more aware of that corporate shield and the risks. I want to touch upon a transition into it as time allows. And I want to talk about multi-member LLCs. The small business slang is a partnership, although it's not technically a partnership, but it has similar characteristics. But this is the scenario that I want to throw out for the listeners and for you, because this is the scenario that I've run into a lot, and I have to believe it's pervasive. I have the scenario where I have a client, single member LLC, and they have an opportunity to take on a partner or another member. Why? Because either that member wants to invest a substantial amount of cash into the LLC. They want to go along for the ride. They want a nice return on their investment, or they want to dump some cash in so that business owner can take advantage of some opportunity, whether it's acquiring a competitor, going into a new market, take your pick. And then, of course, the other scenario is where I'll have a client that has a very successful business. They want to go after another market. I've had this happen a number of times, and they have a partner in that market, a potential partner. And so that individual in that other market has that market, if you will, at the established network connections and everything. That's what they're bringing to the table. My client has capital, labor, equipment, etc. That's what they're bringing. And so they want to form that multi-member LLC. I tell them, going from a single member to a multi-member, you are in a different universe. You're going from Earth to Mars. And my advice to them is I'll help them as much as I can. I can talk about key terms, profit splits, that kind of stuff. But you have to get a corporate lawyer involved here, and there has to be an operating agreement drafted, negotiated, because you're just moving into a whole different world of tax liability, tax ramifications, but also governance and the potential for a minority member lawsuit if you don't run things correctly or if there's a misunderstanding. So talk about that process of that small business owner going from that single member LLC world to this multi-member. What advice can you give on that?
Moving from a single member to multi-member in the most basic form, going from 1 to 2, it's like getting married, at least from a business standpoint. Your business world changes, and you need to think about those things. And most business owners don't necessarily look at it that way. And it may be from just a simple capacity standpoint. I have my small business, and there's somebody else who has their small business, and we can do 1 + 1 is 3. But you need to look at all those things. How do you want to be taxed? It's usually as a partnership, not as a single owner. How do you want to handle the governance structure in Minnesota? And this falls into the double-edged sword flexibility concept. Minnesota is even more flexible than most states. We can have member managed, we can have manager managed, we can have board managed LLCs. And each one of those is a little different. Each owner has equal rights. The default rules in Minnesota, each owner, regardless of how much you think the percentage-wise is, each owner has equal rights. 1 person, 1 vote. That's not how most business owners look at things, particularly if they're not structuring it as a 50-50 membership, LLC, partnership. So you need to look through those things. What option is best for you? Buy-sell agreement. what are the limitations on the transfer of interest, and what are the obligations or opportunities of one member or owner to buy out the other. That alone is probably a separate podcast to talk about all those different things. But when I walk through those with clients, what are the triggering events that can give rise to a buyout? What's the purchase price and how will it be determined? And what's the payment terms? What are the payment terms? And there is no one size fits all. There's just so many different combinations and permutations. And I think anybody who tries to start with a form partnership or form operating agreement to answer all those things is probably not going to have their intent reflected.
Everything that you have covered, I am aware of in one form or the other with bigger companies. I was involved with Sun Country when I was a member and financier, that we dealt with a lot of these issues at a very technical level. So I got a baptism in that. You talk about buy, sell, you talk about governance, whether or not does it boil down to percentage owned? Is it allocated to the manager? Is the governance allocated or authorized through the board, et cetera? Those are all critical decisions that have to be made. And so the perspective of all of these issues that you brought up, and for the purpose of this podcast, is really from what I'm going to call the majority owner, right? So it's my clients that are taking on, in essence, a minority owner, minority defined as being less than 50% of the membership units per se or voting power. Bumping up against our time frame here in this first podcast, which this is what happens when you're having fun here, Dan. The time flies and it's been amazing. But before we wind up, I want to take this discussion back to what I'm going to call the most basic fundamental issue with this that I run into with my clients that I see, that basically negates everything you've talked about from a priority standpoint to a certain degree. And this is what I want to throw at you. We have a few minutes to hear your response on this. And that is the issue where clients will be taking that scenario. They might be going to another market and they have a guy who has contacts and has an established reputation, et cetera. So they want to bring him on board. It's a great idea. 1 + 1 does equal 3 in most of these instances that I've been involved with. But they go into these, but then they form a new entity. They go through that step. But the partnership agreement, if you will, is in many times, it's a handshake deal. It's a verbal deal. That majority owner, what are they walking into when they do something like that?
They're walking into what they hope is a relationship of trust that never goes sour. And they are walking into accepting the default rules of whatever act, the state where they form their entity. As I mentioned before, in Minnesota, the default rule, if you have nothing else, the default rule is you're a member-managed LLC and every member has equal rights.
Which, just to put a finer point on it for the listeners, meaning that if Dan and I formed a multi-member LLC and I owned 95%.
Or you thought you owned 95.
And I gave Dan 5%. Dan, this is all I need you to do. I'm going to give you 5%. It's a good deal for you. Deal for me, right? We shake hands. We don't have anything in writing in the form of an operating agreement. And what you're saying is that if, Dan, you and I are friends and we'll never get into a dispute, right? It'll never happen. But in the real world, it does happen. And so what you're saying is that if that dispute occurs, that you could say, listen, I have equal governance rights to the 95% guy, and he didn't consult with me on this. Is that true?
I could say that. You can have an oral partnership agreement or an oral operating agreement, but then it's going to get to a matter of proving.
Yeah.
And if you can't prove that you were the 95% owner and my recollection is different or whatever, and the decider of fact, a judge, a jury, or whatever, agrees that there is nothing that indicates it was supposed to be 95-5, then it's going to be 50-50.
Yeah. Listen, let's just wrap that point up real quick. Money, you talk about penny wise, pound foolish. That's another phrase I throw out amongst my clients. I'm not shy about it, but not hiring a corporate attorney to help you negotiate those terms, number one, and then draft a very robust operating agreement that protects that majority owner is just corporate foolishness to the nth degree, in my opinion.
A lot of business owners, the last thing they want to do is spend the time and the money on putting together that partnership agreement, that operating agreement. And I get it. They're all excited. The business they're ready to launch their business, or it's ready to grow. They don't want to spend money on legal fees, and they don't want to talk about the business anti-nuptial, if you will, with a lawyer. But if you don't do that and things go south, you really will wish you had.
And that is a perfect way to end this first podcast. We don't want our listeners to really wish that they had hired a good corporate attorney such as Dan. There's other ones out there. But listen, Dan, this has been fantastic. I've learned a lot from this, and I think we've kept this in simple enough terms for the audience. And hopefully, maybe we've saved one sheep out of the thousands that are listening. There, we saved Will. And I think if we could save Will, I think there's hope for everybody else. That's
time well spent.
That's a general conclusion. Thank you very much, Dan. We're definitely going to have you on. We've had some teasers here for future topics, no doubt about it. And it's been fantastic. You've been a gracious, wise guest. It's been phenomenal. So thank you very much.
Well, thank you, Matt.